Mr. Stevens.
Yes, sir. Thank you. Can you hear me now? Yes. I'd like to invite your legal interns to the table. We have the benefit of their expertise and services, I believe, now for another month before they move on to greater and greener pastures. Continuing to do fantastic work for us. Jessica just mentioned that they're helping out in other areas besides just the legal arena, but helping analyze bills and things like that. Janelle is going to briefly give us a status update on a takings case that just came down, a decision in an appeal court that's related to the Federal Court of Claims in Washington, D.C. that we reported on previously. Tori's going to give a very brief update on the Delta Smelt biological opinion remand extension request.
That's Judge O'Neill's case.
That's right, that she had reported on previously, and also give us just a quick tidbit on the Ninth Circuit's recent decision to hear a case en banc by the entire Ninth Circuit dealing with long-term water contract renewals. So I'll turn it over to Janelle first. Or
sure.
Is it? Okay.
So I'm going to discuss Casitas Municipal Water District versus the United States, which is an appeal from the United States Court of Federal Claims. This opinion is relevant to the council because it involves an alleged physical taking of water rights through the implementation of a fish ladder and fish screen to protect endangered steelhead trout, and it defines the scope of California water rights under the physical takings rubric. The Fifth Amendment of the United States Constitution prohibits the taking of private property for public use without just compensation. However, state law and not the Constitution defines the property right. So the Casitas case involves the Casitas Municipal Water District, which operates the Ventura River Project, which is owned by the Bureau of Reclamation. The project provides water to residential, industrial, and agricultural customers in Ventura County, California. In 1997, the steelhead trout was listed as an endangered species under the Endangered Species Act. NMFS released a biological opinion requiring construction of a fish ladder and instituted a flow regime or operating criteria which increased the amount of water bypassing the Casitas facility during steelhead trout migration to facilitate fish passage upstream to spawning sites. These operating criteria were adopted and implemented in December of 2004. And then in January of 2005, Casitas filed suit in the United States Court of Federal Claims, alleging that the imposition of this operating criteria on the project constituted a taking of their property by the United States government without just compensation in violation of the Fifth Amendment. The disagreement at trial focused primarily on the fundamental issue of what constituted the property right in water in California law. Casitas was arguing that the State Water Resources Control Board's water right license to Casitas defined Casitas' property right. In effect, that they possessed the right to divert 107,800 acre feet per year from the Ventura River and the right to put 28,500 acre feet per year to beneficial use for their customers. The government argued that under California law, Casitas had a compensable property interest only in that amount of water it put to beneficial use, regardless of the amount of water it may have diverted or stored. So to establish the taking, Casitas would have to demonstrate that the specific amount of water actually taken otherwise would have been put to beneficial use and provided to their customers. The United States Court of Appeals for the Federal Circuit sided with the government, and the final holding affirmed the dismissal of Casitas' case from the court below on February 27th of 2013. The court reasoned that until Casitas could demonstrate that the deliveries of water to their customers was inhibited by NMFS operating criteria, they couldn't allege a compensable taking of the beneficial use of their water, and thus their claim was not ripe. The court very narrowly defined Casitas' property interest in the water they were diverting to that put to beneficial use. This appears to be consistent with California law, which emphasizes that no one has...
beneficial use is established in the Constitution of California.
Right, and they emphasize that no one has an actual right to the molecules of the water, only to the beneficial use. So we'll continue to monitor this case and provide updates.
Okay. Good. Ms. Sondheim.
First, I wanted to talk about the update on requests for extension of the new smelt biological opinions. As you recall,
Assume we don't recall. Give us a one-paragraph, short paragraph summary of this.
Early in January, the U.S. Fish and Wildlife Services and the Department of Water Resources requested a 3-year extension of the biological opinion because the agencies stated that they
These are the
wished.
current biological opinions, the ones that survived Judge Wanger's previous orders, correct?
That's correct. Well, an extension of the biological opinions that are due in December of 2013. So they have not come out with them yet. They're requesting an extension for an additional 3 years. And yes, pursuant to Wanger's opinion. Because they wish to develop a collaborative science and adaptive management program termed CSAMP, and because of recent changes to BDCP that would also allow for further collaboration for a better biological opinion. On March 15th, they filed their updated extension request, which the court required, and it included a request for a hearing. We're waiting to hear back, but in general, their argument.
The court tentatively ruled rejecting the motion of the state and federal water agencies, and then gave them additional time to submit new arguments to show there's been a change in circumstance. That's my recollection.
That's correct. They filed for the extension, and the court said this is not enough information. We're going to give you until March to come up with something better.
Well, they didn't say it wasn't enough information. They said a decision that you now want to start doing an adaptive management plan may not be a change of circumstance sufficient under the law to grant an extension from a prior order. That's my recollection.
That's correct. It's similar to that, and what they said was that the Science and Adaptive Management Program, that their brief that they had submitted didn't quite meet the factual requirements for the court to extend an extension for the biological opinion. So they needed to provide a brief that shows that there is a significant change in circumstances from when the first date was set for the biological opinion that makes the existing remand schedule detrimental to the public interest. And so as of March 15th, that has been provided, and we're waiting to hear back to see what the court has to say about that brief.
And the opposite party in the litigation has till when to file their response?
I'll get that information to you.
End of this month?
End of this month.
Is there a hearing? We don't know yet if there's a hearing set.
And then the judge will decide whether or not a hearing is warranted.
Okay.
And we'll continue to monitor the progress, and I can continue to give information on this case. Okay. And the second case is the settlement and the Delta Mendota Canal contract renewals. That was the Natural Resources Defense Council versus Salazar, 686 F3D 1092. If I provided a legal update on October 25th. The NRDC requested that the Bureau engage in formal consultation for contract renewal, where there was speculation that a rehearing might be granted. So these are the contract renewals for the water users from the projects. And the argument is that the contract renewal should have gone through formal consultation requiring a biological opinion, and what had happened was they said it's not discretionary, we have to renew the contract, so that happened. And so the request for a hearing was finally granted, and it says, upon the vote of a majority of non-recused active judges, it's ordered they be reheard en banc, and it says also that the 3-judge panel opinion shall not be cited as precedent by or to any court of the Ninth Circuit. And if you'd like more information or to read the opinions that might show some insight as to what they're thinking, the dissent in Natural Resources Defense Council versus Salazar is insightful, and also the Karuk tribe decision on consultation, where the mining activities are required notice of intent because they may affect an endangered species. That was also a case that came out that showed that it might conflict with that opinion. And we will continue to monitor the progress of that case as well.
Okay. Questions, members?
Yeah, this is an important case, and it's an interesting twist in the case. So there was a decision that was rendered, I think it was a 2-to-1 decision that Tori talked about, and the Ninth Circuit had entertained a motion to rehear the case en banc, and they granted the request pretty expeditiously, or at least asked for briefing pretty expeditiously. And so there was some talk amongst the water community that there was something afoot here with the Ninth Circuit. Now they've come out and accepted the case. That doesn't necessarily mean that they're going to overturn.
What did you all think was afoot?
Well, it's an interesting case because this all relates back to OCAP, which we've reported on, biological opinions, which were the basis of renewing long-term water contracts. And there are different nuances in the different types of long-term water contracts that were renewed. Some have inherent shortage provisions in them, some don't. But the basic challenge was that the long-term water contract renewal should have undergone Endangered Species Act scrutiny, and the court initially had said no, that they didn't need to go through that. Now the court's taking another look at it, so we're not quite sure what that means, but it potentially is another. Yes, sir.
Who were the judges on the panel, and how did they vote?
Do you remember the judges who voted in dissent? Because you had mentioned that.
The dissent is Judge Paez, and he said that the plaintiffs must show only that they have a procedural right that, if exercised, could protect their concrete interests, and that's enough to provoke consultation, which didn't happen.
Right. So it was initially a standing. I think that they decided that it was a procedural.
Who voted
Right.
in the majority? That was a dissent?
I don't know. I'll get that information
We'll get the
to you.
information to you, Judge.
Okay. All right. Other questions? Ladies, thank you very much.
Thank you.